Good morning to one and all. I am Dr. K. Satya, Bhama, Department of Commerce B&A. Now let's discuss about the topic relates to discharge of contract. So discharge of contract is nothing but termination of some contractual relation between the parties. The contract is to be discharged when it ceases to operate. That is, when rights and obligations created by it comes to end. That is, when two or more parties have terminated the contract means that is called as discharge of contract. Now let's see about the breach of contract. Breach of contract is also similar to that of your discharge of contract. So breach of contract means failure of a party to perform or fulfill their obligations under the Contract Act, section 82. And a breach of contract means when one party fails to fulfill the obligation without any excuses, without any legal excuses, means that is called as breach of contract. So it may include, there is the breach, cancellation of contract may include not completing work within the agreed time frame, or not deliver goods or services as per their promising, and delivering defective goods or services, and not paying for goods or services. Remedies for breach of contract. So once the contract have been cancelled, there are some remedies that you can able to fulfill. So the party committing the breach of contract is called guilt party, and the other is called injured party. It is the person who is committing a mistake may be called as a guilt party, and the person who is suffering the loss is called as an injured or aggrieved party. So in this, aggrieved party may have one or more remedies against the guilt party. So what are they means? Suit for damage, suit for rescission, suit for injunction, suit for liquidated damages, suit for quantum merit, and then suit for restitution. So what do you mean by damage? Damage is nothing but some monetary compensation for the loss that person has suffered. So the most basic remedy for breach of contract is award giving for the damages. Award is nothing but some compensation either in the form of a money or in form of some other property. But in damage, it's purely related to money. So if a person is suffering from a loss, you can able to compensate that person's loss by giving money to them. Okay, so the next in this various types are there. What are they means? General damage, specific damage, and then exemplary damage and nominal damage. So general damage means it's a natural damage and these cannot be avoided. It's called general damage. Specific damage is caused by some special circumstances. Due to some special circumstances, if a damage is caused means that is called a specific damage. And then exemplary or vindictive damage. So exemplary or vindictive damage is nothing but based on some emotional sufferings or by mental issues. If a person has losses means that is called as exemplary or vindictive damage. Then finally nominal damage. So no loss or damage but get to a record. It is the loss hasn't happened but they are getting they are recording that these damages has been happened. A false or flawful data have been entered means that is called as nominal damage. The next one is rescission. Rescission means a legal process that voids a contract and returns to the party. That is, if it's a remedy that can be caused when a contract is fundamentally flawed. So if any fake contract or if there is no any legal contract or any material error like the say mental based error have been happened means you can cancel those type of contract. That is called as rescission. The next one, injunction. So injunction means order given by the court. So in order to breach the contract, breach means cancelling. So in order to cancel the contract, the order may be given by the court. Usually in this, when one party has ongoing obligation and the other may accept the same. That is called as injunction. The next one, liquidated damage. So these damage is also called as pre-estimate damage. Pre-estimate of damage is nothing but you are providing compensation for the damage which are not calculated. So financially, if you can't able to calculate how much number of damage have been happened, so that is called as liquidated damage. And then quantum merit. Quantum merit is, there is the compensation either given by a person or by a government or by some contractual law. There is a money, so how much amount of loss they have suffered. So based on those laws, uh, deserves, that is we are giving some compensation in either of the form, either in a financial or a property or a house, whatever the thing, that is called as quantum merit. The next one is restitution. Restitution is nothing but refunding the damage. So how much amount of loss you have suffered, so based on those, the amount may be given to them. That is called as restitution. So these are all called as the damages, that is the person can able to claim for the damages. The next one is contract of indemnity and then guarantee. So what do you mean contract of indemnity? Contract of indemnity is nothing but when one person compensate for the loss of other person is called as contract of indemnity. Then contract of guarantee, it is nothing but as per the section 126 of the Indian Contract Act 1872, the contract of guarantee is nothing but an agreement in the eye of law and guarantee, which means you are giving some assurance for the loss that you have suffered. It is called as contract of guarantee. So in both these things, various numerous number of parties are involved. What are all the ways that you can able to differentiate both the contract of indemnity and contract of guarantee are, in contract of indemnity, there are two parties. That is, one is indemnifier and the another one is indemnified. And like the same, in contract of guarantee, three parties are involved. One person is creditor, the another one is principal debtor and surety. Now let's discuss about contract of indemnity. So contract of indemnity, as I have already told, that one particular person may involve or may compensate the loss for the other person, is called contract of indemnity. So in this two persons involved, one is indemnifier, the another one is indemnified. So indemnifier is nothing but one, the person who promises to compensate to the other party for any any loss or damages, that is called as indemnifier. Indemnified is nothing but the person who is accepting the benefit from the other person, is called as indemnified. So the indemnified party may be entitled to recover the damages or any cost or any fund, and whatever may be the thing, based on the compromise he may accept the benefit that was given by the another person. Okay. The next one is number of parties in guarantee. So the number of parties in guarantees are, as I have already told, three persons are there. One is creditor, the another one is principal debtor, the another one is surety. So creditor is nothing but a person who gives money for us to the principal debtor, that is called as creditor. And then principal debtor means the person who receives a loan or any fund from the creditor, and he is the primary responsible for paying back that particular amount. And then surety means the person who give guarantee that the principal debtor will pay back the loan to the creditor, that is called as surety. The next one, nature of obligations. So what sort of obligations may occur in either in a contract of indemnity and in guarantee? So in indemnity, the indemnifier's obligation is considered to be a primary one, and he is of independent in various other obligations. Likewise, in guarantee, the surety's obligation is considered to be a secondary and only comes into play if the primary obligation is not fulfilled. So, the primary is considered to be the base, and only after fulfilling those primary, the secondary obligation of surety may takes into a consideration. The next one, purpose. So, the purpose of indemnity and guarantee is, in indemnity, a contract of indemnity is used to compensate for a loss. Likewise, in guarantee, the contract of guarantee is used to support the primary liability of the third party. The next one is suits. In indemnity, the indemnifier should bring the suit in name of the indemnified. That is, the person who is responsible for the loss of another person must bring the suit in the name of the suffering person. Like the same, in a guarantee, the surety can proceed against the principal debtor in their own right after discharging the debt. So here, surety is nothing but a person who give guarantee to the principal debtor that he may pay the loan in future. Likewise, the next one is legal provision. So in India, legal provision governing contract of indemnity and guarantee has been contained in the chapter 8 of Indian Contract Act 1872. The next one, right of surety. So already we may know that surety means a person who give guarantee to the another person that he will pay the amount in future. So in the surety, there are three types. The one is rights against the creditor, rights against the principal debtor, and then sureties rights against the co-sureties. The first one is right against the creditor. So the right against the creditor is of two types. One is right to securities with creditor, and the second one is loss of securities without creditor's negligence. So first one is right to securities with the creditor. So as per section 141 of the Indian Contract Act 1872, the right to securities with creditor is nothing but the right of surety to get a share in the security. That is, here the creditor have to give security with the surety. It is nothing but whether the surety was aware of security or not. So if the principal debtor fails to make a payment, and what the surety has to do means, the surety have to clear all the payment that was responsible for principal debtor. That is right to securities with the creditor. The next one, loss of securities without creditor's negligence. So creditor is a person who lend money to the principal debtor. So here the creditor takes the security of the principal debtor in case he fails to make any payment. So here the surety what he will do means, he has the right to set off the claim in respect to the value of security from the principal debtor. So here principal debtor fails to make a payment. So in such cases, what the surety is doing means, the surety has the right to set off the claim in respect of value. Okay. The next one is right against the principal debtor. So here in this again two types. One is rights of subrogation. The another one is rights of indemnity against the principal debtor. So right of subrogation. As per section 140 of Indian Contract Act 1872, it stated what do you mean by subrogation means. Subrogation is nothing but forming a new contract to recover the debt from the parties. So forming of new contract is means what? So it is nothing but once the contract have been completed, the person may enter into another contract. So in that particular contract, if they are getting or recovering the debt means that is called as subrogation. So here, as the surety has paid the amount in respect of default payment made by the principal debtor, the surety has to place the creditor and the principal debtor is entitled to repay the loan amount. So that is, surety is taking responsibility for what? For principal debtor's amount. So likewise, the surety takes the place of creditor, because surety pay the amount for principal debtor, instead of principal debtor surety paid. So here surety in turn what he will do means he will collect the amount from the principal debtor. Okay, so the next one is rights of indemnity against the principal debtor. So here under section 145 of the Indian Contract Act 1872, it is mentioned to indemnify the surety. That is, here the contract of guarantee and the principal debtor is obliged to indemnify the surety. So here principal debtor what he has to do means he has to get the advice, and also he has to obey the rules and regulation that have been framed by the surety in aspect of default payment. So if he can't able to pay the amount in due time, the principal debtor has to obey the words of surety. In simple terms, this is the concept. The next one is surety's rights against the co-securities. Surety's right against the co-sureties. In this, again it has three types. So number one is co-surety's right to get release from the contract. So what this indicate means, you are getting relief, you are getting free from the contract. How that can be made possible? As per the section 138 of the Indian Contract Act 1872, the surety may discharge his liability, and here the co-sureties means that when more than one surety gives the guarantee or task to pay the debt of the principal debtor. So here what they are doing means, co-surety means the person other than the surety, we may call it as a co-surety. So here they may get the responsibility in order to pay the debt. This is called as co-surety. So as per section 138, the principal debtor fails to pay the debt and the creditor asks only one surety to fulfill his duty. So this is called as co-sureties to release from the contract. The next one, co-sureties are entitled to contribute equally. So one particular surety fails to pay the amount means the other co-sureties may respond and may take the responsibility in order to pay the amount equally. They may share the debt of the principal debtor equally. That is called as co-sureties equal contribution for the debt that was entitled by the principal debtor. So here, as all these can be made possible by which section? By section 146 of the Contract Act, Indian Contract Act 1872. The next final one is co-sureties is entitled to pay the amount as promised. So what they are doing here means simply as per the due date, the principal debtor is making any default in payment of the loan. Here the co-sureties what they may do, on the specified date they may pay or they may repay the loan amount. That is called as entitled to pay the amount as promised. So they have make a surety, they have give assurance for the principal debtor, and this particular co-sureties are paying the amount instead of principal debtor. So all these may takes place as per the section 147. So that's all the rights. The next one, discharge of surety. So discharge of surety is nothing but a surety is discharged from his liability on various bases. That is, discharge means he is getting relief. So he is getting relief from the duties and responsibilities. So how he is getting relief from duties and responsibilities? There are some cases. What are the cases means? Number one, the debt of surety as regards future transaction in case of continuing guarantee in the absence of contract of contrary. That is, one person have been expired, and based on the condition that particular in the place of that particular person, we can't able to appoint a new person. So in such case, the surety may be discharged. The another one is notice of revocation. Revocation is nothing but cancellation. So here, when the transaction have been disagreed or when the transaction have been cancelled, so in such case the surety may be discharged. And if there is any contradictory between principal debtor and the creditor without the surety's consent, there is without the knowledge of surety, if the principal debtor and creditor are making some transactions, means at the time the surety may discharge his transaction. The next one is, if the creditor releases the principal debtor, the surety may automatically discharge. That is, the principal debtor pay all the amount to the creditor, means the surety may, by default, he may get discharged. Then, when creditor make an agreement for composition or promise to give time, and he is not giving time to principal debtor, so all this happens without the knowledge of surety, means the surety may get discharged from his contract. And the another one is any act or omission to do an act by the creditor. That is, if creditor is making some act or some actions that may give some harms to the right of surety, means he may discharged automatically from that particular contract. When the creditor loses or part with any security which he receives from the principal debtor. So he received amount from the principal debtor, but that was not known by the surety. And in such cases, once though he received the amount and he lost the amount or he lost the part or any property, whatever may be the thing, so in such cases the surety may get discharged. So that's all the discharge of surety. That's all. Thank you.